This court in Syed Abdul Qadir versus State of Bihar Supra held as follows. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to. It would not be out of place to mention here that the Finance Department had, in its counter affidavit, admitted that it was a bona fide mistake on their part. The excess payment made was the result of wrong interpretation of the rule that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence and carelessness of the officials concerned of the government of Bihar. Learned counsel appearing on behalf of the appellant teachers submitted that majority of the beneficiaries have either retired or are on the verge of it. Keeping in view the peculiar facts and circumstances of the case at hand and to avoid any hardship to the appellant teachers, we are of the view that no recovery of the amount that has been paid in excess to the appellant teachers should be made. Premised on the legal proposition considered above, namely whether on the touchstone of equity and arbitrariness, the extract of the judgment reproduced above calls out yet another consideration which would make the process of recovery iniquitous and arbitrary. It is apparent from the conclusions drawn in Syed Abdul Qadir's case Supra that recovery of excess payments made from employees who have retired from service or are close to their retirement would entitle extremely harsh consequences outweighing the monetary gains by the employer. It cannot be forgotten that a retired employee or an employee about to retire is a class apart from those who have sufficient service to their credit before their retirement. Needless to mention that at retirement an employee is past his youth. His needs are far in excess of what they were when he was younger. Despite that, his earnings have substantially dwindled. Keeping the aforesaid circumstances in mind, we are satisfied that recovery would be iniquitous and arbitrary if it is sought to be made after the date of retirement or soon before retirement. A period within 1 year from the date of superannuation should be treated as iniquitous as such.